Good evening, ladies and gentlemen, and welcome to Policy Exchange, and welcome to the second annual Christopher Kingsland Memorial Lecture. Tonight we're going to be again celebrating the life and work of one of the leading legal and political figures of his generation, a man who is incredibly well liked across the political spectrum and regarded with very high esteem by everyone who he had worked with. Christopher Kingsland had a very, very long and varied and very distinguished career. He was first an economist, and then became a very formidable lawyer, then turned to politics, first as an MEP, and then became leader of the Conservative Party in Europe, then as Shadow Attorney General for 11 years, and latterly as Shadow Minister for Legal Affairs. An amazing career, doing all kinds of different things, and also an amazing person by all accounts as well. I am afraid I never worked with him and didn't know him, but I was very struck by what Edward Garnier said in introducing this lecture last year. And he said, his razor-sharp intellect was accompanied by great generosity of spirit, and when he died, peers from all sides of the House spoke of his unfailing sense of duty and integrity. And that's a wonderful thing to say. We're delighted this evening to be able to welcome Christopher's wife, Carolyn. We're honoured to have you here, and very grateful to you for allowing us to name these important legal lectures in honour of his memory. Thank you. So for the second year in a row, we will discuss the subject of human rights. And of course, that is fitting in a sense, because Christopher was the man charged with the Conservative Party of scrutinising the Human Rights Act as it went through the Lords, while Derry Irvine was pushing through the legislation. And reading back his warnings about the significance of the Act at the time for Britain is extremely prescient when you think about the situation today. He said, and I'll quote, "It was a defining moment in the life of our Constitution." And he warned that if it reaches the statute book, it will have an equally defining influence on the balance of power between the legislature and the judiciary. Whatever the inherent merits of its contents, I hope that your lordships will be aware of how deep the implications are for that relationship. They lie at the heart of the doctrine of separation of powers in our Constitution, which has been the hallmark of our liberties through the centuries. That's an important warning. And tonight, to deliver this annual lecture, we're pleased to have Nick Herbert. Now, Nick, as you all know, is very recently a former Policing and Criminal Justice Minister, and he's been in that role driving the most significant reforms of the police for a generation, doing incredibly important things. And Nick also has some form in this area. He, 4 years ago even, was talking, before it was fashionable, about the human rights culture, and warned that it was taking root in Britain, distorting priorities in public bodies and undermining public safety. So Nick has always been ahead of the curve on this issue. He's done some amazing things in government and was, I thought, a very impressive minister making real progress. The only, I suppose the only good thing about Nick no longer being in the government, which is a great loss to them, is a great gain to us, because he can now bring his intellect and really formidable political skills to discussing these important issues. So Nick, it's a pleasure to have you here this evening. Thank you for coming.
Well, thank you, Neil, very much indeed for that kind introduction. Thank you so much, everybody, for coming this evening. I should tell you that I was just running through the pages of my text, and this is true. A number of the pages in the middle of my text have been printed upside down. And it did, I haven't yet spoken to my staff about this, but it did remind me of the story of the brilliant speechwriter who was writing ever better speeches for his political master and getting no praise for it at all. And the political master had begun to rely on these speeches and was never crediting this genius in his office, and had started not to read the speeches before he turned the pages, was delivering a very important speech at a party conference, and concluded this great speech, having worked his audience up to a lather, by saying, first of all, I need to tell you three things. First of all, that inflation is low, and you turn the page. Second of all, that unemployment is coming down. And third, finally, and most important, and he turned the page, and on the page were just written the words, "Now, you old sod, you're on your own." The moral of the tale is always to check your pages before you read them. Unfortunately, I had. I am very honoured to be delivering the second lecture in memory of Christopher Kingsland. and very grateful indeed for Policy Exchange for inviting me. It's a particular pleasure for me to be here with many of Christopher's former colleagues and friends and his wife, Carolyn. I was fond of Christopher, and it was a privilege to work closely with him when he was our spokesman in the House of Lords, a position he held until his untimely death in 2009. He was a Vice President of Justice, someone with a keen regard for the rule of law, but also for the constitutional arrangements which have made England a beacon of liberty for the world. Indeed, it was largely due to Christopher's efforts that the office of Lord Chancellor, with its traditional constitutional role of protecting the rule of law and the independence of the judiciary, survived. Christopher was Shadow Lord Chancellor when the Human Rights Bill was being steered through the Lords, and he told the House, "We often find that the judges in the court in Strasbourg, brilliant and well-meaning lawyers though they are, lack an understanding of our constitutional ways, which are, after all, unique. In that context, putting the interpretation of the Convention in the hands of our own judges has its attractions." How prescient this was. And he went on, "We must be cautious about changing our constitution, which has stood us in good stead for many hundreds of years. Most other countries in the world admire it greatly. Indeed, many are very jealous of it." How right he was. In this lecture, I want to argue that the greatest threat to the cause of human rights and civil liberties in this country comes, ironically, from those who purport to be their most ardent defenders. First, rights have been misinterpreted and misapplied. The very ubiquity of rights in legal and political discourse has actually contributed to what I will argue is their devaluation. Second, we've seen a rise of legalism and a hollowing out of our ethical obligations. Third, rights have come to be deployed for personal advantage rather than as components of our shared humanity. We see this in the pernicious form of the compensation culture, in vexatious litigation, but at worst in lawfare, where rights are deployed as weapons in a political or ideological struggle. Fourth, the law has become imbalanced as the rights of a few have obtained disproportionate influence to the detriment of safety and security and the rights of the majority to go about their business in peace. Fifth, I want to set out how this narrow rights-based legalism, indeed legal elitism, has seen democratic institutions sidelined. And when rights are pitted against democracy, they are vulnerable, because respect for human and civil rights cannot be sustained by courts and quangos alone. It needs every member of society to understand the value of rights. When they are misused, they become harder to protect. I reject the crude accusation that criticizing the rights culture undermines the concept of human rights. Not everything that is done in the name of rights has positive consequences. Indeed, the reverse may be true. Fetishizing rights, with a corresponding lack of concern for responsibilities and duties, has, I believe, helped to bring rights into disrepute. But there is a way to reclaim rights, and I will propose that the UK should complete the process of repatriating convention rights begun under Tony Blair's government by withdrawing from the jurisdiction of the European Court. And I will argue that by doing so, we have the opportunity to redeem rights in the mind of the public, without whose support any institutional protection for human rights surely cannot succeed. In the UK, we can be proud of our record of respect for human and civil rights. It is almost 800 years since habeas corpus and the right to a fair trial were hardwired into our constitutional arrangements. Magna Carta and the Bill of Rights helped to inspire. In revolutionary France, the Declaration of the Rights of Man, and in the embryonic United States, their own Bill of Rights. Then, in the aftermath of the Second World War and the Holocaust, we had to ensure that the abuses that had taken place, genocide, oppression, torture, and truly dehumanizing, degrading, and debasing treatment, never happened again. And it was British lawyers who helped draft the Universal Declaration of Human Rights and the European Convention. But the framers of those documents were grounding them in rights and liberties which they presupposed our citizens to enjoy. They reflected rights and liberties which had already been fought for, won, and incorporated into our constitutional arrangements. As Edmund Burke observed, from Magna Carta to the Declaration of Rights, it has been the uniform policy of our Constitution to claim and assert our liberties as an entailed inheritance, derived to us from our forefathers and to be transmitted to our posterity. 2 years ago, I visited the concentration camp at Dachau. I saw tiny cells where inmates were forced to stand 4 days, a housing block with hooks from which prisoners were hung as a form of torture, a museum with stark photographs charting chilling stories of political prisoners interned as enemies of the state, of others incarcerated for being of the wrong race or sexuality. It was gross abuses such as these which spurned the creation of the Universal Declaration and the European Convention. Documents focused on what I would call great rights: the right not to be tortured, to a fair trial, to free speech, to life, to liberty and restrictions on arbitrary detention. As the organisation Liberty asks, what's not to like? Yet something new has happened. Human rights have become an object of opprobrium, not a claim. I recently attended a fundraising event hosted by Human Rights Watch, an organisation which, as you know, helps people who suffer some of the most egregious breaches of their rights, monitoring those governments which operate with a casual disregard for the rights of their citizens. And a guest on my table explained that she had been assailed by her taxi driver on the subject when she had explained where she was going. Now, I don't pretend that taxi drivers are necessarily representative of public opinion, but it occurred to me that something tragic is happening. Respect for human rights should represent one of the pinnacles of civilization. Instead, human rights are too often now derided. And much of the blame for this must lie in the fact that litigants and, yes, lawyers have, in applying the concept of human rights in sometimes trivial and inappropriate ways, contributed to their devaluation. What my colleague Dominic Raab, MP, has referred to as rights contagion. The prisoner who argued that the failure of his in-cell toilet breached the prohibition against inhuman or degrading treatment. The father who kept his son out of lessons, claiming that his school's ban on ponytails breached his human rights. Each year, Liberty hosts an awards ceremony to honour those who have advanced the cause of human rights. And last year, one of the nominees was a 12-year-old boy who had worn a skirt to school in protest at its uniform policy. But it's not just trivial cases such as these, which courts more often than not have the common sense to throw out, that have contributed to this devaluation. As Professor Richard Thompson Ford has pointed out in his brilliant book, Rights Gone Wrong, cynical opportunists and reckless extremists on both the left and the right have hijacked civil rights, using them to gain personal advantage at public expense, to push radical schemes despite democratic opposition, and in some cases even to reverse and undermine the social justice goals civil rights were supposed to achieve. Because in the modern environment, rights are seen, to use the philosopher Ronald Dworkin's words, as trumps, which take priority over social welfare and other forms of moral obligation. So those who have wanted a greater focus on, for instance, protection of the environment or greater welfare have felt compelled to frame these campaigns as being for the recognition of new rights. There's been, as Lord Justice Laws recently put it, a tendency to treat "I have a right to" as a synonym of "I would like." And regrettably, the courts, and in particular the European Court of Human Rights, have been complicit in this. The Strasbourg Court's conception of the Convention as a living instrument has allowed it to go way beyond simply applying the Convention principles to new developments, to creating entirely new categories of rights through its interpretation. As one president of the court has noted, it has interpreted Article 8, the right to respect for family and private life, to cover issues as diverse as corporal punishment in schools, disclosure of medical records, aircraft noise, assisted suicide, and the application of immigration rules. So a Romanian prisoner was able successfully to use Article 8 to sue prison authorities over the smell from a neighbouring rubbish tip. The stale air didn't damage his fraudster's health. The court was clear about that. But he was rewarded, nevertheless, with £6,500 worth of damages for the damage to his quality of life. A further consequence of our obsession with legally enforceable rights over other forms of moral duties has been an increasingly litigious society. And this has coincided with an increased willingness by the courts to question the actions of government, and that was accelerated by the Human Rights Act. In 1997, Lord Irvin, of course one of the architects of the Human Rights Act, predicted that a culture of awareness of rights would develop in its wake. But what has actually been unleashed is a culture of grievance. Once the Act was in force, its advocates encouraged the public to use the Convention rights to effect changes and make new demands for the delivery of public services. This was legalism in action. with quangos and interest groups using the courts to achieve through litigation what they could not achieve democratically. And far from developing a respect for human rights, Lord Young's report for the Prime Minister last year noted that a blame culture has developed in which somebody must always be at fault and financial recompense is seen to make good any injury. This in turn leads officials and sometimes ministers to take decisions motivated primarily by concern to avoid legal challenge. Since the mid-1980s, civil servants have been warned and in turn have warned ministers of the so-called judge over your shoulder. As a result, we've seen decision-making skewed in favour of the path of least resistance. I experienced this as a Justice Minister. My colleagues and I have long pointed to the chilling effect of the Human Rights Act in relation to the naming of offenders in the community, in particular those who have escaped or absconded from custody. In fact, in 2009, we announced that we would allow the authorities to name offenders at large. I discovered, when in government, that officials were proposing to block the release of information on dangerous offenders on the run, including convicted killers and sex offenders, on the grounds that to do so would breach their rights. It seemed to me that there was a very strong public interest in releasing this information. After all, there was no question that releasing it would drive them underground, as is so often asserted in relation to sex offenders, because the truth is that these people were already lost to the authorities. Moreover, it seems to me that in seeking to block this information, too much importance was being placed on the rights of offenders, and rather too little on the rights of members of the public. The default setting, until challenged, was to suppress the information and thereby avoid anyone challenging the policy. But legalism gives rise to larger problems than just litigiousness. As Richard Thompson Ford says, rights go wrong when we lose sight of their highest purposes. There is a tendency among professionals, and among those whom David Blunkett perhaps pejoratively has termed the liberati, to prioritise process over the public interest, to become overly attracted to rules and procedures, and to confuse those for great principles. The overriding principle of justice is to convict the guilty and acquit the innocent. But remember the protests when the then government allowed courts to draw conclusions from a defendant's exercise of the right to silence? You would have thought that they were proposing to put suspects on the rack. Or take the limited exemption allowed to the double jeopardy rule. In some cases, the blunt instrument of double jeopardy intended to promote acquitted defendants from oppressive retrials thwarted that overriding principle of justice, so Parliament amended it. Yet when Gary Dobson, one of the killers of Stephen Lawrence, was brought to justice, the organisation Liberty was asked if they would like to comment, and they declined to do so because they campaigned against that limited reform. What the case of Gary Dobson brought out is that the moral purpose of justice is the reason we have rules of law, but we should not confuse those rules with justice itself. When society is conceptualised only through legal rights and responsibilities, it is diminished. Narrow legalism provides a framework for society, but it cannot provide a comprehensive morality. The aspiration of some supporters that the Human Rights Act could amount to a new overarching morality, values for a godless age, to coin one phrase, was surely misguided. And this is a point which has been developed by Professor Guillermo Veridami, who argues that the warm embrace between international law and human rights has reduced, and some would say impoverished, argument about liberty into a legal and often legalistic form, a technical argument about rules, open only to those with a training in human rights law. Even lawyers from other fields are dismissed by the human rights clique because their credentials are allegedly not good enough. And he notes that this is the reason why human rights judgments so often jar with the public, because they clash with what he says are the deep-seated liberal moral intuitions of large sectors of society, who have no difficulty accepting that torture is a political, social, and certainly a moral evil, but refuse to put the deportation of a convicted foreigner or voting rights for prisoners in the same category. How can we believe in democracy if we don't believe that the public's moral intuitions are essentially sound? But a functioning democracy also requires that people have an understanding of their responsibilities. Responsibilities are not the opposite of rights. They go hand in hand. Every right places obligations on others to respect those rights, sometimes to facilitate them. But as Jonathan Fisher QC notes, the Convention is hopelessly unbalanced by its omission to incorporate any notion of civil obligation into the text. Of course, in a free country, the responsibilities we owe to the state should be as few as possible. But that is not to say that we don't have wider responsibilities to society at all. Responsibilities to one another. Responsibilities to use scarce resources wisely. Responsibilities to protect the environment for this and future generations. A responsibility, for that matter, to ensure that we don't pass debts incurred through our own profligacy onto those generations. Social responsibilities or duties, those we owe others, not to the state, may not be legally enforceable, but that doesn't make them any less important. As Richard Thompson Ford says, civil rights make sense only as part of a social contract of mutual respect and cooperation among citizens, where the rights of others and the common good are as important as personal entitlements. An increasingly atomistic view that privileges our rights above our responsibilities can actually build boundaries between us. As Lord Justice Laws has said, the assertion of a right is systematically self-centered. When X asserts a right against Y, he is making a claim that his interest should come first. And rights viewed in this way can become instruments of aggression. We see this in our prisons, where inmates with time on their hands and grievances to pursue are positively encouraged to litigate first and even discouraged from reporting matters to the proper authorities. One current advertisement, for instance, states, if you have been a victim of violence in prison, the powers that be probably won't help you. See if we can. Vexatious litigants in prison may be annoying and expensive, but they are, in general, safely out of harm's way. The same, sadly, is not true when those whose ultimate aim is the destruction of our way of life, including our traditional liberties, are allowed to make a mockery of our legal procedures as part of their ideological struggle, a practice some commentators have called lawfare, law as a mechanism of war by other means. As the former Home Secretary Lord Reid has pointed out, the Convention was drafted to deal with the fascist state, but we now face the challenge of fascist individuals who exploit our legal system as part of their struggle against values which we hold dear. And it's precisely because their attachment to those processes is superficial and instrumental that this lawfare is asymmetrical. It's darkly ironic that preachers of hate, who so despise our Western democracy, think nothing of sheltering under its protections. And they're able to use every possible legal device to prevent their being brought to justice, while governments struggle to fulfill their fundamental duty to protect the public. Now, as a point of principle, we should not demur from our commitment to human rights and civil liberties. That would be to hand victory to our opponents. But that doesn't mean that we should allow liberal democracy to become an object of ridicule. That, too, would be to hand victory to our opponents. We should hold true to our principles, while recognizing that the way in which we manifest those principles may need to change. So, for instance, our commitment to justice usually requires that it should take place in the open. But sometimes it's necessary, in the interest of justice, to do otherwise. So we allow rape victims to retain their anonymity. We close trials of juveniles. We limit access to family courts. Justice is not served if governments have to settle cases out of court because they're unable to adduce evidence due to genuine national security concerns. The aim of reasonable security measures in a liberal democracy is to protect citizens and their rights, not to undermine them. Yet by looking at one set of rights alone, we so often lose sight of that aim. No less a figure than Sir Robert Peel observed that liberty does not consist in having your home robbed by organised gangs of thieves. If the strong opposition to Peel's plans on the mistaken grounds of civil liberties had succeeded, he would not have been able to found the Metropolitan Police. Yet such reflexive sentiments find their echo today. Moreover, if rights are trumps, then the right to life is, as one eminent philosopher put it, surely the ace of rights. The state has a positive duty to protect the lives of its citizens so that they can enjoy the full panoply of freedoms that come with living in a free society. And on occasion, the rights and liberties of others may have to be curtailed in order to facilitate this. I do not believe that those who commit crimes or preach hatred or seek to undermine democracy and the rule of law thereby forfeit all of their rights. Of course not. But I do believe that where a balance has to be struck between the rights of these people and the human and civil rights of the law-abiding, then the latter should take priority. And too often, those who purport to speak up for human rights and those charged with guaranteeing them, including the European Court of Human Rights, get this balance wrong. As the Prime Minister told the Council of Europe, you can end up with someone who has no right to live in your country, who you are convinced and have good reason to be convinced means to do your country harm, and yet you cannot try them, you cannot detain them, and you cannot deport them. So having put in place every possible safeguard to ensure that convention rights are not violated, we still cannot fulfill our duty to our law-abiding citizens to protect them. Ultimately, the first duty of any government is to protect the security of its citizens. After all, if a foreign terror suspect out on bail because he can neither be detained nor deported were to commit an atrocity while at large, it's not the courts or the Special Immigration Appeals Commission who Parliament and the public would hold to account. It's the Home Secretary and the Prime Minister. It's understandable that in the aftermath of World War II, the drafters of the Convention sought to constrain the activities of governments. However, even among the representatives, there was a divide between those from countries such as Denmark, Norway, Sweden, the Netherlands, and the UK, who felt that representative democracy was the best protector of liberty, and others, including Belgium, France, Italy, and Ireland, who felt that rights could not be secured without a supranational court. But one of the British representatives, the Labour MP Lynn Ungo-Thomas, shortly afterwards a High Court judge, argued that for a court to be empowered to decide whether a legislature had violated the rights of its citizens was the most anti-democratic procedure we could possibly conceive. And the result was a messy compromise in which states were permitted to sign up voluntarily to the jurisdiction of the court. It wasn't until 1966 that the British government agreed to do so. And this development came towards the end of a period in which the court had very little impact. But it coincided with a domestic legal and political movement that was distrustful of the ability of elected representatives to secure human and civil rights. In 1968, Anthony Lester published his call for the European Convention to be directly incorporated into British law. And through the 1970s and 80s, lawyers and later increasingly the courts came to question the capacity of Parliament itself to protect fundamental rights. Professor Francesca Klug, in the last few days, has claimed that parliamentary sovereignty is a misnomer in our system. It really means government sovereignty. But that's surely wrong. Though it may be unfashionable to say so, the evidence is that Parliament has never been more independently mandated than it is now. The heyday for partisan voting was the 1950s. MPs can no longer afford to treat their electorates with the disdain that was possible in previous decades, and a good thing too. Conversely, nor should we assume that the detachment of judges and tribunals from the people guarantees benign decision-making. The logical endpoint of such an argument would be that the people would best be served by a dictatorship of the judiciary. In fact, Parliament has shown itself to be a doughty defender of human rights and civil liberties. Defenders of the Human Rights Act like to portray it as Winston Churchill's legacy, but it was the chamber of the House of Commons, that little room, that Churchill described as the shrine of the world's liberties. It was Parliament which stood firm against 90, then 42 days detention without trial. And going back further in history, it was Parliament which ended the slave trade, gave women the vote, and ended the criminalisation of homosexuality. And looking forward, I'm confident that Parliament will soon say that the right to marry should not be restricted on the grounds of a person's sexuality. And that's a matter on which the European Court of Human Rights has declined to intervene. Ultimately, fundamental human rights can't endure if they rest on narrow legalism alone. They require the support of the public. And as I said in a lecture at the British Library 4 years ago, human rights can't be an elitist ideal imposed upon an unwilling public. Jefferson might have believed that men's rights were endowed by their creator, but he also believed that to secure these rights, governments are instituted among men, deriving their just power from the consent of the governed. And as the late Lord Bingham put it, respect for the law is likely to be undermined if groups can achieve through the courts what they cannot achieve through democratic means. Yet too often, the Strasbourg Court has failed to recognise this point. Instead, it has seen itself as better placed than national governments to balance the rights and the implicit responsibilities in the Convention. in Lord Hoffman's words, the Strasbourg Court has taken upon itself an extraordinary power to micromanage the legal systems of the member states. This aggrandizement has taken a number of forms. We see it in the court's caseload, nearly doubling in just over a decade. We see it in the growing backlog of over 150,000 cases awaiting a judgment. And we see it most in the court's conception of the convention as a living instrument, allowing it to reinterpret the convention to go way beyond what was intended by its signatories. The court does not limit itself to reinterpretation in the light of changing circumstances. For instance, applying notions of freedom of expression drafted in the 1940s to cover the digital technology age, or applying the right to family life to gay and lesbian couples. What it actually means is creating new rights, which in some cases the contracting parties had deliberately excluded from the convention. So, for instance, Dominic Raab has shown that the drafters of the convention deliberately left out the right to vote, conscious, amongst other things, that in the UK the franchise was not extended to peers, lunatics and convicted prisoners. Nonetheless, in the case of Hurst, the court decided that the right to vote was a right that people ought to have, so they concocted it from a much more limited requirement on states to hold free and fair elections. And this also reflects another legitimate criticism of the court. It's too often paid lip service to the doctrine of the margin of appreciation while ignoring it in practice. As Lord Hoffman said in his Judicial Studies Board lecture of 2009, the court has not taken the doctrine of the margin of appreciation nearly far enough. It has been unable to resist the temptation to aggrandize its jurisdiction and to impose uniform rules on member states. It considers itself the equivalent of the Supreme Court of the United States, laying down a federal law of Europe. Nor is it only British judges who have been critical. The president of the Belgian Constitutional Court has complained that the Strasbourg Court is now acting as a court of fourth instance. And as a recent example, only this month in Redfern, the court argued that British employment law was incompatible with the convention. Redfern was a bus driver who stood as a counsellor for the BNP. When his colleagues protested, he was sacked. He was unable to sue for wrongful dismissal because he had been employed for less than 12 months. The court held that the 12-month qualifying period for unfair dismissal rights did not afford sufficient protection for employees' right to freedom of expression and association. And as a result, it's likely that the UK will have to pass a new law extending protection against unfair dismissal to reasons connected with political activities to new employees. Now, it may well be that there's an argument for doing so. After all, we've seen only this weekend in Rotherham the dangers of authorities discriminating against people on the basis of their party affiliation. But equally, making it harder to sack new employees actually discourages employers from taking on new staff, which is why Parliament recently voted to extend the qualifying period from 12 to 24 months. The point is this: a democratically elected Parliament is better placed to judge this balance than an unaccountable court sitting in another country. As the dissenting judges put it, doubtless the balance could have been struck in a different way, and further exceptions to the qualifying period might have been created to cover claims for dismissal on grounds of political affiliation. However, this is a different question from the one which the court is required to determine, namely whether the United Kingdom exceeded its wide margin of appreciation. But perhaps the most concerning aspect of the European Court has been its impact on national security cases. In particular, the willingness of the court to issue interim measures in cases of removal, extradition or deportation has enabled a series of individuals, some with criminal convictions for terrorism and hate crimes, others with no right to be in the UK in the first place, to thwart removal from the UK. Perhaps the best example of this is the case of Abu Hamza. The US formally requested Hamza's extradition in September 2006, and it was approved by a judge within a few weeks. Yet it took over 6 years for Hamza to be deported, because each time a decision was made, he would appeal and deportation would be postponed pending it. In the case of Qatada, the court extended the principle first formulated in Shahal, that a person cannot be removed to a country if there is a real risk that they will face torture, to cover the risk that a person might face a breach of Article 6, the right to a fair trial, specifically the risk that evidence obtained by torture might be used against him. Now, domestic courts have long held that evidence obtained by torture should play no part in British legal proceedings. And let me be clear, torture is abhorrent and has no place in a civilised society. But Qatada is not in any danger of being tortured. The UK has agreements in place with Jordan that guard against that risk, and both our courts and the European Court accept that those assurances would be effective. Nor is there a risk that other people will be tortured if he is deported. As Lord Phillips put it in the lead House of Lords judgment on Contagion, the prohibition on receiving evidence obtained by torture is not primarily because such evidence is unreliable and will make the trial unfair. Rather, it is because the state must stand firm against the conduct that has produced the evidence. That principle, he said, applies to the state in which an attempt is made to adduce such evidence. It does not require this state, the United Kingdom, to retain in this country, to the detriment of national security, a terrorist suspect, unless it has a high degree of assurance that evidence obtained by torture will not be adduced against him in Jordan. Yet that is precisely what the European Court required. Nor did the court even insist that Qatar show that such evidence would, or even probably would, be used against him. They said that such evidence was necessarily hard to find, and therefore all that would be required would be evidence of a real risk that torture evidence might be used. We shouldn't underestimate the seriousness of this matter. We have the President of the Supreme Court telling us that an interpretation of the Convention rights now adopted by the Strasbourg Court means that we have to accommodate on our streets a terrorist suspect at the expense of national security. And as a direct result of that ruling, a domestic tribunal has been forced to release a man described by a High Court judge as a truly dangerous individual. Our inability to remove those who threaten our country isn't just ludicrous, it is in fact an outrage. And this situation should not be allowed to continue. Faced with a choice between our national security and the rights of our citizens to live in safety and the perverse judgment of the Strasbourg Court, a responsible government must be allowed to put the safety of its citizens first. So what's to be done? Earlier this year, Ken Clarke led negotiations in Brighton designed to address some of the problems of the European Court of Human Rights. This culminated in a declaration designed to encourage the court to deal with its backlog, prioritise only those cases which deserve to be interrogated by an international tribunal, and pay greater regard to the margin of appreciation. I hope that these measures will succeed, although I note that the first response of the then President of the Court was to say that the declaration would not change the way we do our jobs. And after all, the Brighton Declaration followed Interlaken and Izmir, which made similar exhortations. However, judgments such as Redfern, to which I referred, and the court's insistence that the UK's restrictions on voting by convicted prisoners are contrary to Protocol 1 of the Convention do not give grounds for optimism. Because even if less trivial claims are no longer entertained, the fundamental fault line remains. A supranational court can impose its will against ours. And this, in the end, represents a challenge to democracy which cannot be allowed to stand. In 2010, the Conservative Party stood on a platform of introducing a British Bill of Rights. Our hope was that a domestic Bill of Rights, true to our historical legacy, which placed rights in the context of the responsibilities we owe to one another, would allow us to make greater use of the margin of appreciation in Strasbourg. And in line with the pledge made in the coalition agreement, the bipartisan commission on a Bill of Rights was established last year under the chairmanship of Sir Lee Lewis. I look forward to the commission's recommendations. However, its terms of reference mean that the obligations that the UK has as a signatory to the Convention are not, I understand, open to discussion. And so its findings may well be limited if they are to secure consensus between the Commission's members, some of whom I'm very pleased to say are here today. And I fear that whatever the merits of that policy, when we adopted it in 2006, the approach of the Strasbourg Court now means that a British Bill of Rights, alongside our obligations under the Convention, as interpreted and enforced by Strasbourg, alongside our obligations under the Convention, would give us no greater flexibility than we have at present. The Parliamentary Joint Committee on Human Rights, which took evidence on this point, has concluded that it's both legally and empirically incorrect to suggest that a Bill of Rights would lead the European Court of Human Rights to give a greater margin of appreciation to the UK. Indeed, the opposite would most probably be true. The Human Rights Act requires domestic courts to have regard to Strasbourg jurisprudence, not slavishly to follow it. But the ruling in Allah effectively demands domestic courts to do just that. I quote, "to keep pace with the Strasbourg jurisprudence, no more, but certainly no less." However, as Baroness Hale has noted in a lecture on the margin of appreciation, when dealing with a British Bill of Rights, the Allah-type reasoning would not apply. The Convention would remain as a floor, but there would be no ceiling. And this was also the conclusion of Ministry of Justice-sponsored research by the University of Oxford, which found that a British Bill of Rights would most likely result in stricter rights protections in British courts. Far from giving us greater discretion to strike a balance between liberty and security, a British Bill of Rights, complementary to the Convention, would give us even less. Our courts would remain bound not only by the Convention and Strasbourg's interpretation of it, but also by our judges' interpretation of the British Bill of Rights. So I now believe that an accommodation with the Strasbourg Court that will respect the proper role of the British Parliament and domestic courts is a pipe dream. And the current standoff over prisoner voting demonstrates this point. The government may have been able to comply with one of the demands required by the Council of Europe by tabling draft legislation within 6 months of the judgment in Scopola, but it's simply incapable of complying with the second part of that requirement, which is to enact that legislation. Because I don't believe that the House of Commons will vote for any relaxation in the ban on voting rights for convicted prisoners. And that means that future cases will come before the court. 2,500 are already in the pipeline. So far, Strasbourg has refused requests for prisoners to be awarded compensation. It's unlikely that this will last once it becomes clear that Parliament has no intention of complying. The British public will find it hard to stomach the sight of prisoners lining up to receive thousands of pounds in compensation. We could, of course, do as some suggest and simply ignore the ruling. But if one believes that lawbreakers should not be lawmakers, then the reverse is also true. We cannot simply ignore international law that we have signed up to. We might, as the Blair government considered, when unable to deport terror suspects overseas, denounce the Convention and re-sign having made a reservation, in this case in relation to prisoner voting. But this would only address the immediate issue of prisoner voting, not the long-term potential tension between the UK, our courts and Strasbourg. And be in no doubt, there will be further conflict. Tomorrow, the Grand Chamber will hear an appeal in Wittner versus the United Kingdom, which concerns the legality of whole-life tariffs. The court previously held, by the narrowest majority and on a technicality, that whole-life tariffs are compatible with the Convention. However, there was only a single vote in it. The minority held that depriving the prisoner of any hope for the future breached the prohibition against torture and inhuman or degrading treatment. If the Grand Chamber were to overturn the ruling and side with the minority, which is entirely possible, the UK would face having to set parole eligibility dates for some of the most notorious offenders in our jails, people like Rosemary West and Levi Belfield, the killer of Millie Dowd. One can only speculate how the public would respond to such a ruling. But the point is this. I raised it to show that if not prisoner voting, there will be another issue. We can't keep kicking this particular can down the street. So I propose a more radical solution. We should complete the repatriation of the Convention begun by Labour in 1998, finally bringing rights home. We should make our Supreme Court truly supreme by giving it prime responsibility for the oversight and enforcement of Convention rights. Over the past decade, British judges have shown themselves perfectly capable of interpreting and applying the Convention rights. Accepting the jurisdiction of the Strasbourg Court is not the only way of ensuring that Convention rights are protected. It is a task our domestic institutions are perfectly capable of performing. Unfortunately, the option of withdrawing from the court without formally denouncing the Convention is no longer open to us. We should have to go through the process of denunciation provided under Article 58. But I am not suggesting that we should in any sense denounce the rights contained in the Convention. They are now written into our law through the Human Rights Act and will continue to be so as part of a UK Bill of Rights. Fully repatriating the Convention rights and withdrawing from the jurisdiction of the Strasbourg Court would not require us to withdraw from the Council of Europe. Membership of the Council requires states to respect the rights contained in the Convention, and we would continue to do so. Nor would it require withdrawal from the EU. The Lisbon Treaty requires accession states to be party to the Convention, not existing members. Indeed, the European Union sees itself as an observant of the principles of the Convention without being subject to its machinery. Some would ask what signal it would send to other countries, such as those in Eastern Europe, were the UK to withdraw from the jurisdiction of the Strasbourg Court. As Dr. Pinto Jasinski, who's here, puts it, without endorsement, the only reason, so the argument goes, that Russia tolerates adverse ECHR judgments is that the governments of other member countries of the Council of Europe also are subject to the same process. However, once we accept that the UK will not abide by the ruling in Hurst, then the question must also be asked, what signal does it send for the UK to remain a signatory, willfully disregarding a ruling of the court and an instruction from the Council of Ministers? In any case, the court has already shown itself impotent when dealing with member states which have little regard to the rights of their citizens. There are over 8,000 unimplemented judgments of the court. Almost 2,000 concern Turkey, over 1,000 Russia, almost 1,000 are against Poland. Just 40 UK judgments are outstanding, fewer than France or Germany. It's often suggested that to withdraw from the European Court would leave the UK isolated as the only state apart from Belarus that is not party to it, and we would somehow be a pariah state. But looking more broadly, countries such as Australia, New Zealand and Canada have repatriated ultimate jurisdiction to their domestic courts without signing up to an international human rights court and without becoming in any sense pariah states. On the contrary, their courts have developed a corpus of human rights law that English courts can draw upon and would be freer to do so were they not required to give Strasbourg jurisprudence priority. So I propose that we should resile from the European Court of Human Rights, repeal the Human Rights Act, and introduce instead a UK Bill of Rights. And in doing so, we could also address some of the flaws in the operation of the Human Rights Act. To conclude my case today, of course the most basic human rights stand as moral absolutes: the right to life, the prohibition of torture, the wrongfulness of slavery. I do not deny that we have wider rights: rights to privacy, to dignity, to representative government, to freedom of thought, expression and association, to property, to be treated as individuals of equal worth, to marry and form families, to justice. But these later rights, civil rights, social rights, talk of our place in society. They may be uncertain in application, and on occasion they conflict, and they exist in competition with other social imperatives: to secure economic well-being, to secure a safe and healthy environment, to advance health and well-being, to promote peace and ensure security, to give people the liberty they need to flourish as individuals, to enable people to take the responsibility that is also necessary to flourish as individuals. And these competing social aims can only be satisfactorily aggregated through social mechanisms, above all through democracy, not through the narrow prism of legal rights. Great harm is being done by allowing rights to derail other important social needs. And I believe that ultimately those who focus solely on rights, to the neglect of both the rights of wider society and its interests, do it a disservice. As Professor Thomson Ford warns, distracted by the wrong rights, we may neglect to right wrongs. And great harm is also being done by allowing respect for rights to be undermined. At the Human Rights Watch event, which I mentioned earlier, I heard a brave Zimbabwean speak movingly about the threats and violence he has faced for exposing brutality in the country's blood diamond mines. It's terrible abuses like these around the world that we need to address. None of us should want to see the idea of human rights devalued in the eyes of the public. That is why we must now take the bold steps needed to see rights redeemed. Thank you.
Well, thank you, Nick. It's detailed forensic stuff. It's very powerful stuff as well. It's an exciting moment in this debate, so we're incredibly pleased to have you come and deliver this lecture here. We've now got a little bit of time for some questions and answers. If you'd like to say who you are and where you're from, there's a roving mic which will come to you. We're going to start, I think, with the go next to him. Thanks very much.
Joshua Rosenberg, my name. Nick, you said that we should withdraw from the jurisdiction of the Human Rights Court and denounce the Convention. But you said that we wouldn't have to leave the Council of Europe, which is the body that runs the Court and the Convention. We know that any country that wants to join the Council of Europe has to accept the Convention and the jurisdiction of the courts. How can you be so sure that we wouldn't have to leave the Council of Europe? And if your answer to that is, well, it wouldn't matter very much, Then you come on to the EU, you say we wouldn't have to leave the EU. But of course, no country can join the EU unless it's first a member of the Council of Europe. And you may say it wouldn't matter very much if we were to leave the EU. But how can you be so sure that we wouldn't have to leave the Council of Europe and the EU? And the second part of my question is, how close is what you said tonight to the government's policy? In other words, how likely do you think it is that this will be in the next Conservative manifesto?
Okay, Joshua, well, I mean, first of all, your first question is surely a legal one, and it's a question that lawyers will have to answer. I'm not a lawyer. I believe that it is, on a study, that it is legally possible to remove ourselves from the court. I hate this expression, denounce the convention, because it sounds as though we denounce the principles, and we should not. But legally, that is the expression. I think that people like me have to start from a position of what we want to do, and lawyers must advise on what are the steps and possibilities. But we should surely want, in my view, to do those things and remain a member of the Council of Europe, and that is my understanding that we can. What I note about this argument is how it immediately shifts onto what it says about the position of other countries, other member states in the Council of Europe, and not as to whether human rights will be protected in this country. I note that in the response to the points I was making last week in calling for us to leave the jurisdiction of the court, that nobody was saying, rights won't be protected in this country, how could you possibly advocate such a thing? There seems to be an assumption that rights would be protected perfectly well. Indeed, I'm sure that they would be, with the combination of our Parliament and our courts. Interestingly, immediately the argument moves to something quite different, which is that we can't possibly contemplate this, irrespective of our own interests, because it will have an impact on others. Now that is a completely different debate. It's one that I think we should engage in, and I made the swift point that actually these countries are not paying attention to the European Court now, and therefore to pretend that there isn't an existing problem, and that somehow Britain's withdrawal would create that problem, seems to be an error. But it is a different argument. And to your second point, what I'm proposing is clearly not the policy of the government. I mean, we have a coalition government. It is committed to being party to the convention and the court. Prime Minister said so in his speech to the Council of Europe that he made a few months ago. That is clearly the existing position of the coalition. It is very difficult to see how that would change given the Liberal Democrat component of the coalition. But the Commission, and there are members here, is looking within that architecture at issues like whether the creation of a domestic bill of rights would give us a greater margin of appreciation and therefore help us with some of the objections, which I think there is quite a lot of common ground we have to the current system. I sought to argue, I suspect unhelpfully to the Commission and to the government today, in the short term, but I believe helpfully in the longer term, that actually we won't be able to square that circle, and that it's time to have a debate which puts on the table something that has been taken off the table, which is whether we should go on accepting the jurisdiction of the supranational court.
Hi Nick, my name's Jonathan Davis. I'm here as an individual, just because I'm interested in the subject. I'm a lot more worried about legislation that might mean a state official who doesn't like my face could just lock me up and have a court trial, and therefore not really be under any obligation to produce a case against me, just think I want him out of the way. I'm a lot more worried about that than I am about being blown up by a terrorist. One of the things that really worries me is the threat to the rights of individuals versus the state. Now, in your speech, you mentioned that a lot of these rights were to do with safeguards against fascism, and I think that's probably correct. And if I think about a lot of the things that you were critical of, for instance, you mentioned double jeopardy, well, surely that's there to make sure that some member of the state doesn't just say, well, we're going to put this guy on trial again and again and again until we get the result that we want. You were very critical about the rights of prisoners to vote, and I'm sympathetic to that. On the other hand, what if you did get a fascist government? Then maybe that's something that could safeguard against that happening. So, in a sense, I think if we start to think that we don't need to respect these rights, then we're already descending down the path of fascism. I think that happened under the previous government. I was very horrified at a lot of the things the Labour government did, and I was really rather hoping the coalition would reverse some of those things. Having said that, I'm very sympathetic to your criticisms about rights in the sense of individuals saying, I have a claim to this. So I think it's very important we protect the liberties of individuals versus the state. But sympathetic with what you say about unreasonable claims.
The range of points there which you got to.
Yeah, I mean, first you're right that there were two parts to my critique. One was about the growth in the compensation culture, the devaluation of rights, and the other was about a misapplication, and particularly in relation to security matters. You know, I think it's a category error to see security and liberty in some kind of conflict, because I think that the foundation of our security is actually our liberal democracy, and we should seek to protect that. What I was arguing is that in making efforts to strike that correct balance, I think sometimes we lost sight, as Sir Robert Peel believed, that critics had lost sight of the very importance of protecting those liberties. You know, and it was a nice example that I used. I mean, there was a very fierce then parliamentary criticism of the formation of the Metropolitan Police on the grounds that it would infringe people's liberties, and freedoms, historic freedoms, that people should be empowered to be agents of the state and seek to coerce citizens in going about what was considered to be their lawful business, or at least certainly their right to conduct unlawful business. And Peel saw through that. And so the point I'm trying to make is that there is certainly a balance to be achieved here. These are decisions, this moves me to my second answer, which I believe ultimately Parliament has to take. And I argue that Parliament it has been the guarantor of our freedom. So actually Parliament rejected many of the most egregious suggestions that were made by Tony Blair's government. And Parliament must have that right, but also a responsibility to do that. And I don't believe that a fascist government will be elected in this country, but we do have elections. We have a democracy, and an important part of what I was trying to say is that you can't, in the end, separate the conception of rights from the will of the people. That unless the people subscribe to this notion of rights and subscribe to the architecture, it will become divorced from them as some kind of separate elitist construct, where effectively people are saying, we know better than the people what is best for the people, and we cannot trust their elected representatives to represent the people. That, I think, is the real road to ruin. That, I think, is the real dangerous path. That we ever allow institutions to set themselves up and say, actually, we think the people are wrong. And I think that when you start to see a public outcry over proposals that have been made by this court over things like prisoner voting, the merits of prisoner voting really are the point. We can debate all of that. What matters is the sense that a decision which should probably be ours is being taken by someone else when they have no entitlement to do so. And that, it seems to me, is very damaging to democracy and to public confidence in democracy.
What's the problem with Hitler was democratically elected?
And let's pause that for now. There's a lady in the very back row, and then we're going to come to the front.
Hi, I'm Angela Patrick, and I'm here from Justice. There's a lot of things we agree on, and a lot of things we disagree on, clearly. I agree that human rights aren't just for lawyers, and they never should be. And actually, I agree that Parliament has a clear responsibility as a democratic institution to protect not just our liberties, but the international standards that are recognised in human rights instruments. But I want to ask a question about a bit of the detail of your speech, where you talked about a distinction being drawn in a British Bill of Rights between certain core rights and other rights which you saw as more properly protected through the social process. Now, some of those you identified included privacy, dignity, and freedom of expression. If we just look at privacy and freedom of expression, there are some very important issues that have been determined judicially, actually in Strasbourg. Things like the proper scope of a DNA database, and the discretion that should be afforded in looking at stop and search, and looking at freedom of expression, issues like the protection of journalistic sources. And I suppose my question is, if you remove judicial protection, either domestically or at Strasbourg, for those rights and how the balance should be drawn, and place the responsibility for drawing the kinds of balances that are currently drawn both by our domestic judges and by the judges at the European Court of Human Rights, is there adequate protection there offered in what could be blunt instruments of a general election every 5 years? I'd question and query that. And secondly, what protection are you offering for minorities if the social process is solely to be determined by one arm of government without a check on the others?
The thing is that what creeps into your question is kind of a what I think has underlined a lot of the growth in the resort to human rights legislation to achieve certain social ends, which is a kind of lack of faith in democracy and in the parliamentary process. And you say, what will happen if there's a general election? Well, you know, elections are a nuisance, but they are the expression of popular will, and we elect governments that pledge to do things. That is the very foundation of our liberty in this country. It's the very foundation of it. And I don't think we can be so dismissive of it. In some of the areas that you describe, actually what's happened is that Parliament has declined to enter into certain areas, and the courts have taken licence, and specifically licence, under the Convention and then the Human Rights Act particularly, to start making law. And the right to privacy is, I think, the classic example. Parliament was very wary of forging a right to privacy. Has declined to do so. There has been no bill that has sought to create a right of privacy. You can see in the context of the current discussion about press freedom this week that there is considerable reticence still on the part of parliamentarians to do this, now for whatever reasons. And what has happened is that courts have decided, well, Parliament hasn't done this, but we're going to take licence under the principles of the Convention to shape the law of privacy ourselves. Now, in this room, it may well be divided to those that think that's a good thing, and that the court's building of a right of privacy is a good thing. There are others who think it's rather a bad thing, but there's not much that you will be able to do about it, because there's no democratic involvement here. Let's take a general licence under the principles of the Convention to do it. And so the editor of the Daily Mail resorts to railing against the judge who he thinks is particularly responsible of it, and the judiciary themselves have to take a view about what they think are the limits in terms of the public interest of extending this right of privacy. But extending it they are. And I think that's quite dangerous, actually, for the judiciary themselves, because I think it draws them into the political arena. That's another argument that I could have made, actually. And I did make in my previous speech to the British Library. So what that takes you back to is, in the end, that I think Parliament has both the right and the responsibility to legislate in this area, and should not must not ignore the importance of minorities. Has to take the responsibility for deciding what the right balance is in relation to things like freedom of expression. But what should not happen is that Parliament deliberately decides one thing, and somebody else says, well, we're in defiance of that. We're actually going to go ahead because under the general license of the Convention principles, we're going to do the opposite. That becomes, in my view, quite a damaging challenge to the democratic process.
Just before we come to the front, there was I think a response point that Michael looked like he wanted to make. The microphone is going to
I just was a bit surprised by Angela's comments there to Michael Kintilishinsky instead, because I don't think that in your excellent and rather full speech, you didn't say that everything should be handed over to Parliament. You were saying that it should be handed over to British judges rather than continental ones. So what would happen is that we would still have the British judges who would judge under the Human Rights Act, but the only difference would be that if they said that some act of Parliament was incompatible with the Human Rights Act and issued a declaration of incompatibility, then in those circumstances Parliament would, in exceptional cases, and they would be very exceptional cases, be able to override it in the democratic interest. So what you're actually supporting is a democratic override as a last resort, rather than Parliament taking no notice of judges altogether. So I think you are completely misrepresented, and I must say it's not the first time that justice has misrepresented things. Since when I had my publication for Policy Exchange, I was also misrepresented.
Well, maybe that as a point of information, as you want to come back.
Well, no, I've only said that I think you are. I'm making a comment on Justice's comment, but I think you are, in substance, what you said, exactly right. And I think actually one of the interesting points here is, I mean, Parliament, under my proposals, would remain sovereign. I said that the Supreme Court should be supreme, but as the Supreme Court under the current arrangements. And the interesting question is, if you took the jurisdiction of the European Court away, how much more emboldened the Supreme Court might become in our own country in this area. And I think that would be something that would be worth discussing.
Well, I can see the hands on the clock moving around, so we've only got time for a couple more questions. We're going to come to the front, watching very patiently, and then we might take some questions together in groups of two, if that's all right, if you wouldn't mind. So,
yes, I'm Martin, and I'm a barrister and member of the Commission on Bill of Rights. Now, I just wanted to pick up a point that developed in the interchange between this gentleman here and yourself, which was the, if you like, seeming paradox of the last Labour government, which on the one hand, at the beginning of its term, introduced the Human Rights Act, avowedly pro-libertarian move, and then in its behaviour during the course of that administration, proposed, sometimes got through and sometimes unsuccessfully proposed, quite a lot of extremely anti-libertarian measures, including prolonged detention, charge for criminal suspects, and other measures. And why, the question I ask is, why does this paradox occur? And I think that there may be an underlying reason for it, which is the belief that once you've farmed out the protection of rights to a judicial process, you yourself don't really need to bother about them. Because as long as you can scrape by the minimum standards and not be struck down by a judge or ruled incompatible by a judge, you can do anything. Now that seems to me very unfortunate, because it removes from Parliament what should be its primary responsibility, to consider our rights and liberties, and not just consider them by reference to this minimum standards framework, but to consider them properly and fully. And I hope whatever arrangements we end up with and go forward with, that they are arrangements which don't put the courts in opposition to Parliament, in the protection of our liberties, but instead assist Parliament itself to exercise judgment and responsibility and to work, if you like, together with other elements of the Constitution, the judiciary and the executive to that end.
Interesting point. Do you want to come back on that?
I mean, I agree with that, and the point I was trying to develop, and perhaps was unable to do so, is I think if you move in the way that we have to such a focus on rights, you do, it seems to me, lose responsibility, lose focus on responsibility, and it seems to me that in so many areas and at so many levels that has happened, and I'm rather intrigued by your analysis of the way in which the previous government felt licensed to make some of the proposals it had because it had protected human rights in some other way, whereas actually Parliament must be the place where such very important balancing considerations are taken. I'm always very struck by the criticism that was advanced of some of the measures that were taken, which were seen to be repressive and so on. Whereas actually, one of the things I tried to point out was the House of Commons has been quite jealous of guarding liberty and rejected a large number of these measures. I mean, I was first elected in 2005, and shortly after that, Tony Blair's government, still with a very large majority, lost a vote in the House of Commons precisely on one of these issues. And that's been the first time in whatever it was, 8 years, I think, that he'd ever lost a vote. And it resulted in a period of detention before charge that was considered still to be greater than was desirable, and Parliament later reduced it. But he lost the vote on what the executive had originally proposed. And I think that's often forgotten.
We're a bit over time. We might just take a couple of last questions. There's a lady who's waiting a long time in purple, and there's a gentleman at the very back row there.
My name is Henrietta Doyle. I'm from an organisation called Inclusion London Disabled People. And I've got a question regarding the Bill of Rights that you support and the UN Convention for the Rights of Disabled People, which is a very clear, simple, easy to understand document and contains important rights like the right not to be abused, as Winterbourne View shows is still needed, the right to information in accessible formats, which, having met blind patients in the hospital who can't read their appointment letters and have missed their hospital appointments, so that's still needed. And probably the most pertinent at this time is the right to support, to live independently and take part and be included in the community. With the austerity cuts, which are being imposed by councils due to central government cutting the budget, disabled people are becoming cut off from their community, marooned in their own homes. And there may be a case where there isn't protection under domestic law, that there is a need to go to an outside body to demand a right, a basic human right. So my question is the rights within the UN Convention for Disabled People, will that be integrated into your Bill of Rights for the UK? If not, I'm concerned that the baby's been thrown out with the bathwater.
Well, let's hold that thought for a second and take a gentleman in the middle of the back row. And we're going to come just to the front for the last question.
John Samuels. I thought I was a member of a beleaguered class until Martin spoke. I'm a retired judge. My question is simply this. If, through diplomatic channels, the government manages to procure withdrawal from the convention, inevitably that will take a significant amount of time. Our involvement in the Convention is as a result of engagement with a treaty. Withdrawal from a treaty obligation takes time. The question is, would you, in that situation, with an ultimate withdrawal from the Convention, expect this government, or any other government at the time, to honour the judgments of the European Court of Human Rights, which precedes our withdrawal? In other words, would you adopt the proposal of Lord Bingham, who cited that the rule of law must prevail?
One last question.
Thanks. My name's Carl Gardner. I'm a law blogger. You dealt quite briefly with the question of EU membership, but there is an EU aspect to this, isn't there? Because even if your policy were followed, human rights could be litigated through the gateway of EU law, certainly in some areas, perhaps employment, movement of EU citizens throughout Europe, if we selectively opted back in even to crime and justice measures, and the scope of that wouldn't be easy to contain. So I wonder whether your policy implies anything in terms of EU policy as well. Do we need to repatriate human rights protection through EU law too?
So you've got three good questions there on the content of what's in domestic rights, what you do about the case law, the existing stuff, and then also ECJ.
Yeah, okay, so in reverse, I wasn't talking about the role of other supranational courts, and I mean, there clearly are crossover issues. One of them is in relation to prisoner voting, where there may be a role in relation to the European Court of Justice, because it becomes a matter of EU law. I am not trespassing on that area, or indeed the wider questions of EU membership that gives rise to. Those are questions for another lecture by another lecturer. Though I might have views, but you know, I accept that there are some areas of, if you like, overlap and so on, but I deliberately didn't seek to try and open up those questions as well. I was quite tempted to wear the tie of the International Court of Justice that I was given last week by one of its judges, but decided that I wouldn't do so, because I didn't wish to try and suggest that there could be no proper role for supranational courts. I just don't think there's a role for this one. Second question, John, your question, and again, it seems to me to be, you know, I'm not going to try and answer what seem to me to be the sort of legal questions or the matters, the practical matters about how quickly things could be done. But the force of my argument is that the current situation, and those that argue that we should simply ignore the court, that is not an acceptable position to take for Britain. I mean, I find myself actually in agreement with those who are saying that we should implement the decision on prisoner voting to this extent, which is that it's not acceptable to say, well, we just won't do so, but then to go on being party to the court and the convention, because actually, ultimately, I think that does undermine the rule of law. And I think it's perfectly acceptable for the government to play for time and so on in the way that it has sought to do. But ultimately, I think there will be a kind of crunch point where we have to decide. And the solution I advanced was precisely because I do think we need to, you know, uphold the rule of law, and that requires the law to be seen to have legitimacy and democratic legitimacy too. And then to answer the first point first about the rights of the disabled, I mean, it seems to me that what you were suggesting did begin to expose what I think is the problem about the broadening of rights beyond those rights that were first set out in the Universal Declaration and then in the Convention what I called the Great Rights, because I think some of the things that you suggested may indeed be highly desirable, but start trespassing into what I think are essentially matters of social policy, as to whether somebody has the right with a small r to independent living. In the end, can only be provided by public authorities that decide to commit resources to this kind of thing, and those resources have to be committed by governments taking decisions through their elected administrations through the government in deciding this is how we are going to allocate the resources. And I think the use of rights legislation to force out resource allocation decisions like that is a grave mistake. I think it's a mistake for human rights legislation. It puts judges in a position where they then start saying this is how resources should be used, when it should be elected politicians who both have the right to decide how resources are allocated, but also the responsibility too, and cannot and should not absolve those sorts of decisions to others, or simply fall back on the idea that they can deny some kind of resource allocation and it might be challenged and then they'll be forced to do it, so that's okay, but they'll just see if they can get away without providing it. And that seems to me to be exactly the problem, that this extension of the attempt to try and lever up standards, for instance, in public services, through the legalism of applying rights doctrine, for all of the reasons I've said, is highly problematic. It devalues rights, it puts judges in the political arena, and it will result in wrong resource decisions being made, and it will result in decisions being made where the public don't think they've been party to the conversation. And for all of those reasons, whatever the merits of the particular things you suggested, and I'm sure they are very powerful, you know, I don't think it's necessarily right that those should form part of the great rights that I am discussing here and which we should be seeking to uphold.
No, I think that's a really interesting point to end on. Nick, your speech this evening has been absolutely fascinating. It's been interesting to hear this debate, which is an important public debate going on out there, taken to a much higher level than I've heard it before. And I think the brilliant questions we've had from the audience this evening have taken it further as well. And that's been fascinating to hear. So it only really remains to thank you for your brilliant lecture. This has been the second year in a row, absolutely fascinating. And so it only remains for us to thank you in the conventional